Maine's Freedom of Access Act, or FOA. FOA essentially is there for the purpose of open government, for transparency, and even though I'm beginning to feel like this is an endangered word, for democracy. Because in a democracy, or at least a functional one, people need to know what their government is doing so they can decide what they like and what they don't like and vote accordingly. There are two components of FOA. The first has to do with public records, and the second has to do with public proceedings. So let's start with public records, because that's the one that by far is more significant. And yes, this really is the statutory definition of a public record. Any written, printed, or graphic material, or any mechanical or electronic data compilation from which information can be obtained directly or after translation into a form susceptible of visual or oral comprehension that is in the possession or custody of an agency or public official of this state, and has been received or prepared for use in connection with the transaction of public or governmental business, or contains information relating to the transaction of public or governmental business. Everybody that thinks a lawyer must have written that, do raise your hand, because yes, this is a very lawyerly paragraph. But what does it really mean? How do we reduce this to some key points? Well, first of all, it includes more than paper records. Specifically, it includes electronic records and electronic data compilations. A second important point, it pertains to records that actually exist. In other words, FOA is not about creating records, it's about identifying what exists. Third, they need to be in the possession or custody of a government official or government agency. And finally, it has to be a record that's related to the transaction of public or governmental business. I like to say that that explains why my grocery list, which is written on the back of a meeting agenda and was being done while I was sitting there trying to ponder whether or not I was actually in the wrong meeting, is not a public record. There are exceptions to what is a public record. Here's the big one. Records that have been designated confidential by statute. Another one that we sometimes see are records that would be within the scope of a privilege against discovery or use as evidence. That's an exception that protects communications mostly between you all and me. And an exception is personal contact information concerning public employees. Sometimes there are records that are some parts of which are public, but they contain confidential information. That means that the agency is obligated to redact, which is a lawyer word for blackout, confidential information contained in an otherwise public record when the agency or the official determines that it can be done in a manner such that public access to the record can be provided. Some statutes, though, or situations make the entire record confidential. What are the public's rights with respect to public records? Well, the statute says they're entitled to inspect and copy them. During the regular business hours of the agency or the public official having custody of the record, within a reasonable time after making the request. Now, the agency can charge some fees related to public records requests. First of all, the agency can charge a reasonable fee to cover the cost of copying. Second, an agency can charge a fee to cover the actual cost of searching for, retrieving, and compiling the records of not more than $25 an hour after the 2 hours of staff time, the first 2 hours per request. And that also includes reviewing and redacting confidential information. If a translation is necessary, the agency or official can charge a fee to cover the actual cost of translation and inspection, translation, copying. It may all be scheduled to occur at such time as it will not delay or inconvenience the regular activities of the agency. So, back to FOA. There is no legal requirement that a FOA request be in writing. An agency can certainly ask a requester that they put the request be in writing. And the reason that you do this is because that way you have a clear record of when the request was made and received and what were the records that were requested. So my bottom line for you is, if the requester will not put it in writing, you put it in writing. In other words, you document the day you got the request and what was requested. And if the requester has given you the right contact information, you should go ahead and send the requester an email saying, thank you for speaking with me about your FOA request. My understanding is that you're looking for X. If this is incorrect, please contact us back. In other words, you're closing the loop so that everyone's clear about what has been requested. What happens next? The central office is going to need to respond to the FOA request with a 5-day letter. What's a 5-day letter contain? First, it's an acknowledgement of the request. Second of all, it's an opportunity for the agency to ask for clarification of the request. Also, you need to inform the requester if the request is denied or is expected to be denied in whole or in part. And what we generally do is we raise issues and tell the requester that we won't be able to specifically know what we can produce versus what's going to be denied until we see the actual documents. Within a reasonable period of time, the agency has to give a good faith estimate of when records will be produced and of costs, if any. So now you have to actually produce the records. To be clear, the records do not have to be produced within 5 working days. I would say about half of the FOA requests that I see, the requester will announce, this is a FOA request and I'm entitled to have the records within 5 working days. Actually, no. What you're entitled to have within 5 working days is a 5-day letter. The records need to be produced within a reasonable period of time after the request was made. What is reasonable? Well, okay, classic lawyer answer. It depends. It depends on the scope of the request. It depends if the records are in many different locations or in one location. It depends if the records are going to need to be redacted to remove confidential information. All of those things can make what's a reasonable period of time. So for a long time, we had a debate about making the records available. In other words, telling requesters, okay, they're here at the 5th floor, come see them, versus mailing them to the requester. Generally speaking, we do not ask people to come in and review them for a couple of reasons. Okay, the first and obvious one are all the COVID protocols that we've put in place over the past few years. But the second one is, generally speaking, it's easier to simply scan the documents in and send them electronically than have people traipsing around the 5th floor, finding a conference room, and telling them to put Post-it notes on anything that they want a copy of. I mean, to be clear, that's compliance with the law. But on the balance of inconvenient for staff versus any incidental benefit, I don't know, that they might not tag every single document that's responsive. Now, generally speaking, we just send them out. All right, some common misunderstandings about FOA. This is the biggest one. FOA is not a record retention statute. In other words, You are not violating FOA if you don't have a record that the requester thinks you should have. Not a FOA issue. The agency has no obligation to create records or summaries of records to satisfy a request. In other words, the requester can't say, I don't want all 500 pages of that. Just tell me the following things. Nope, that's not how it works. However, sometimes the agency chooses to provide a summary because the agency thinks that that is either more helpful to the agency or limits information that might be able to be used for purposes that the agency might not want it to be used for. The agency can choose to create a record or a summary like that, but that is not required under FOA. And if the agency does choose to do that, if the person or requester comes back and says, no, actually, I think now I'd like all of them, they still get all of them. The agency has no obligation to answer questions under FOA. So sometimes we get FOA requests, and then as soon as it's been sent out, we get an email back saying, I don't understand the following things, and wanting to start a dialogue about the records. That's not FOA. You have no legal obligation to engage in any of that. I will note that that does make the requester very unhappy, because at this point, armed with the information they received, now they really want to talk to someone about it. And being told that that's actually not their right under FOA is never a favorite. Finally, there is no such thing as a standing FOA request. No. In other words, FOA is at a point in time. It's what do you have at the time of the request, not whether you might get something that's in the same category or similar to what's being requested after the request. Okay, that's the end of public records. Public proceeding. A public proceeding is the transaction of any function affecting any or all citizens of the state by boards, commissions, agencies, and authorities. However, sometimes there might be an advisory organization or a task force. Those are generally thought to be covered unless the law, resolve, or executive order creating it specifically exempts the organization from the application of this subchapter. Public proceedings require notice if the body or agency consists of 3 or more persons. It requires that they be open to the public. The public is able to record either audio or video the proceeding. There is no requirement that the public be allowed to either speak or participate in any way. Also, as long as it complies with statute, there can now be either partially or fully remote public proceedings. That's something that is a lingering takeaway from the COVID era. Before COVID, you could not have remote public proceedings. And as a result, we had folks in Maine traveling great distances to get to public meetings. That is not necessarily any longer, because there are ways that organizations can, working within the statute, have either a partially or fully remote public proceeding. For proceedings for which notice is required, a record gets made within a reasonable period of time that itself is open to public inspection. In other words, you can have it under FOA. The record includes the date, time, and place of the meeting, the members of the body recorded as being either present or absent, and all motions and votes taken by individual if there is a roll call vote. Executive sessions. Bodies that are subject to public proceeding requirements can also go into executive session. It can't be used to defeat the purpose of FOA, and it's limited to the discussion of specific types of matters defined by statute. You go into executive session by a motion to enter executive session, and that motion must identify the statutory basis for the executive session. Even if deliberation is allowed in executive session, all final acts or approvals of the body must take place in public. So what are the consequences if you defy FOA? Well, requesters can appeal the denial of access to records to court. Decisions made by a body that should have been made in a public proceeding but were not can be voided. And if it's found that you engage in a willful violation of FOA, there can be a monetary penalty assessed. Anyway, that is the very long story of FOA.